Welcome to Unraveling Intellectual Property with Michael Stein podcast, as we lay out and simplify the various aspects of intellectual property law. We hope you enjoy this episode. This new podcast, which I'm very excited to begin, is going to cover a wide range of intellectual property issues, including patents, copyrights, trademarks, trade secrets, you name it. If people have suggestions, we'll have some guest speakers. So hopefully it'll be an exciting time. And today I have one of my esteemed interns, Russell Pigg, who is going to be essentially the moderator for today. So Russell.
Thanks for having me on, Michael. I feel honored to be the guest for the first episode. And so we're going to start on a three-part series of trademarks today. And part one is going to be introduction to trademarks. Part two, we'll discuss the differences between the different types of trademark registrations. And in part three, we'll have a general discussion about some trademarks in everyday life. And so to start things off, what is a trademark? And what is the difference between what a trademark protects versus a copyright or a patent?
That's an excellent question. A trademark can be a name, it can be a logo, it can be a combination of a name and a logo, it can even be a sound, and it could be a color. So there's many different types of trademarks, but the function of a trademark is to identify a source. It's to identify who is producing or selling the good or the service. And in that regard, it is unique from, say, copyrights, which is a work which is reduced to a tangible, readable medium, and it can cover computer programs, it could cover sculptures, it could cover movies, music, and it doesn't necessarily identify the source. With respect to patents, that covers inventions. It could be a new laser, it could be a new type of truck, a new energy source, and it could also be a design which has a functional component to it of a product.
Okay. And so can a trademark be something that you have been used previously?
Yes. Unlike patents, it is possible to get some rights, and we'll discuss more about the differences of the different types of trademarks, I believe, in the next episode. But you can acquire trademark rights from the day you start using it, or selling your product, or selling the service that you may provide.
Great. And so if someone's looking to file an application for a trademark, or they just want trademark protections in general, what should that person have prepared to show, and what do they need for that filing?
Well, there's different bases in which to file a trademark, and one of them is based on use. And for that, we would need to provide a specimen. This is for actually federal registration. For common law, we would need the name of the owner. But other than that, common law is granted from the time you start using it. And therefore, when it comes to, say, a federal registration or even a state registration, you need to identify the goods or the services that are being used. It could be both. And you need to include who the owner is, whether it's an individual, or it could be a company, or it could be an LLC, it could be a nonprofit. Nowadays, the USPTO requires that you have an email address of the owner. You also need to use, if you're not US domiciled, you need to have a US attorney handle it, which is probably advisable anyway, because I've had many instances where things are worse when someone already filed something and I have to try to clean it up.
I can imagine that. And so Do you we got a little bit into common law, state registration, and federal registration. I look forward to getting into that a little bit more in part two. And so just right off the bat, you would recommend filing through an attorney for federal registration to get the best protection?
Generally, but everyone's got a different circumstance. Everyone's got a unique situation. It's possible to gain at least a priority date for federal rights based upon an intention to use. We also need to consider whether you're going to file internationally. So there's treaties like the Madrid Protocol, which need to be considered foreign priority, which is something that needs to be considered, whether there's a foreign registration or whether we want to have a foreign registration. So there's lots of issues to consider. Do we want to file something? Do we want to file a logo? Do we want to file it in color? So there's a lot of factors to take into account. We can get more into that in a later seminar or later episode, but it's not so easy to say that federal registration is necessarily the best, although that is often the answer.
All right. Well, I think that'll be it for part one. I look forward to getting more into that in part two. So thank you for listening, and we'll continue this in the next episode.
Thanks for tuning in to Unraveling Intellectual Property with Michael Stein. If you have any questions, please feel free to contact us at email@steinip.com. Follow us on LinkedIn and Facebook, and subscribe to us on YouTube at Stein IP LLC.